And we're live. It is Tuesday, November 2nd, 5:04 p.m. Eastern Time, 2:04 p.m. Pacific Time, where Orin is. And we're 4 minutes late because Orin had some tabs open. And I know, we're like all about placing blame in the proper places
It's like
here.
the tort system.
Exactly. But we're not allowed to have fun anymore, but we are allowed to have Orin Kerr back on the show. And Genevieve was the genesis for this. I think that Genevieve, do you want to talk about kind of what you were curious and wanted to talk about today?
Yes, please. I was just really excited because I was reading one of Orin's tweets and he made a comment about the current Supreme Court term and how they weren't really selecting any Fourth Amendment cases. And I thought it would be kind of interesting just to discuss the court just generally and also how their discretion kind of gives the court's characteristic. And I was thinking particularly because I'd seen you speak about the Warren Court and how they handled race and how that became kind of not a theme, but a topic that they really focused on. And I find it surprising, and I'd love to hear your thoughts on this, why this particular court is so reticent to deal with Fourth Amendment issues, or perhaps it's just not top of mind for them, while they will willingly engage with a lot of substantive rights issues, while they'll engage with like First Amendment issues, specifically around religion. And I think particularly there's a lot of administrative law issues that are coming up too, but I could be wrong.
Yeah, so the Supreme Court has almost entirely discretionary calls as to what cases to put on their dockets. There are some cases that they get that are mandatory, but Congress has basically said it's up to the Supreme Court to decide what cases to give themselves. And so they just pick the ones that, they have a standard under Rule 10 of the Supreme Court rules that basically says we look for circuit splits, disagreement among lower courts, and that's the most important thing that the Supreme Court looks for. And so it's mostly using lower court disagreement as a proxy for what the U.S. Supreme Court should take, should put on its docket. And what that means is that like a lot of issues that are super important where the lower courts are agreeing will just never get reviewed by the Supreme Court. And sometimes a lower court judge understanding
like the meaning of Section 230.
Like the meaning of Section 230, yeah, that's a good example.
Wait, no.
And sometimes lower court judges will understand Rule 10 and will kind of intentionally prod them with a circuit split in order to see, like, maybe we can get this to go up. I don't think they shouldn't do that, but they do sometimes. And so it's basically based on the assumption that the justices are generalists and they really don't know what's going on and what's right or wrong below. They are just deciding the cases they decide, and so they look for confusion in lower courts as a proxy for like what they should be hearing. It's almost like a delegation of authority to lower courts.
Do you teach Fed courts, Orin?
I don't.
Yeah, I never took it.
Never have. Great course. I'd love to teach it some. That's one of my would love to teach someday classes, but I never.
See, I should have subbed in crim law for Fed courts. That would have been given the teaching the people who were teaching Fed courts that year would have been good. I think Neil Katyal was teaching it. That would have been amazing. Anyway, but like I'm actually kind of a little bit curious, and one of the things was that Genevieve and I were kind of talking about beforehand was about like the how, which is the Rule 10. But one of the things that like I think is kind of interesting, and I was going to ask you about, is like you can certify a question to appellate courts as a district court all the time, but the upper level appellate courts, or an intermediate appellate court, like can you certify? Like I don't think the circuit courts can certify a question to the Supreme Court, but Nope. State courts do that all the time. And like, so is that just not a mechanism that's in the rules? That's like the main reason.
Yeah.
Or because like, yeah. I mean,
there's no way of doing that. So it's basically the higher level you go, the more control you get over what you're doing.
Right, but that's not true of the state system. Like you can have the New York State Court of Appeals lets you you can certify a question to the Court of Appeals. They don't have to take it. Right.
The Fed courts can, but the
that's what I'm saying. It's like it's not.
They can. I see. So you're talking about sort of like flagging an issue for the higher court to take with a request that they take it.
Yeah.
Well, the lower courts can do that sort of. Like you'll see opinions written by judges where they say, we sure would like the U.S. Supreme Court to hear this. And the justices take that pretty seriously, where, it's like, oh, okay, that's a
But
signal.
when I do that, they don't seem to take it nearly as seriously, and I have a hard time not taking that personally. So, Orin, I want to take Genevieve's question to its logical extreme. If you have a court that decides its own docket, and in a similar fashion also decides the extent of the binding nature of its own precedent, which is to say they can follow their own precedents if they feel like it. They generally do, but there's nothing forcing them to, and they always have the option of saying, that Plessy v. Ferguson thing, please forget we ever said it. In what sense, when Amy Coney Barrett stands up with Mitch McConnell and talks about how the court is not political, they seem to earnestly believe that, and Steve Breyer has been on a speaking tour assuring everybody that they're not political. And you say, here's a group of 9 people that decides what issue they hear and decides if they want to follow their own rulings on those issues or just make up something new. Our word for that is political. And so my question is this just rhetoric, or in your arena, the Fourth Amendment arena, is there something that really meaningfully distinguishes the Supreme Court's adjudication of things from more overtly political adjudications?
Okay, so there's a whole lot in there to unpack. And so one part of this is, I think, the fact that the Supreme Court has a discretionary docket and has the power to overturn its cases, it means it has a lot of power. And that could be exercised in various ways. I mean, the fact that they have a lot of discretionary power will make it possible for them to use that power in political ways that might otherwise be cabined by rules. So in that sense, they're free to be political if they want to be. But, I think they do exercise, that includes they could decide to exercise their power in ways that are not political, at least in kind of a partisan sort of, I think most people would think of political sense. It's funny that when the justices say that they're not political and everybody kind of goes, you've got to be joking. I think there's something going on there, which is the difference between the vessel for review and the process for vessels being sent out into the world, if this makes sense. So if you're a justice,
you're going to have to unpack that.
Yeah, I don't actually know what you mean by vessels. Like, who's the vessel? Like,
the justices, that made
Vessel
no
is
sense.
loaded.
Let me make the last minute of what I said. Let me try again.
over.
So imagine it's a political system. You're a member of the Senate and you're the president or working in the White House. You want a candidate who is reflecting your views, right? If you're the president, you want a nominee who's going to advance your political agenda. If you're a member of the Senate, you want somebody who's going to advance your political agenda. So they're politicians acting politically in the sense of who they nominate and who they confirm. And of course, they say all sorts of non-political things. This is the true commitment of the embodiment of the rule of law. I'm so delighted this person is here. It's amazing they exist, and they're just true. They're just Lady Justice, and that they're absolutely perfect. And they have an incentive to say that, but of course they're politicians, so they're going to do that. If you're the nominee, you probably look at the world differently in the sense that, like, they're not saying like, you better rule this way in this case. They're like, we picked you. It so happens you have a judicial philosophy. Now, a lot of justices have, I think, an overly sunny view of their judicial philosophy, as if they just sort of happen to find certain arguments persuasive and other arguments unpersuasive, in a way divorced from their politics. And I think usually what happens is, like, there's a couple different theories that are on the table, and there's the one that always leads to results that you like. Well, that's a cool theory. I got to think more about that. That's pretty persuasive. And so the justices are there, nominated by politicians, confirmed by politicians, and then are choosing among options that seem appealing to them, which is being propelled by their politics, but they themselves will not see themselves as acting politically. So I think there's a way of reconciling this that is sort of reconciles their subjective ways of talking about what they do and our ways of thinking about the world they're in. That kind of it puts it all together. They're not lying, but they're only seeing a piece of the puzzle.
So can I just I think that this is really good. And I know we're talking about the Supreme Court today, but I think that this becomes an issue writ large for how we talk about judges and the judicial process generally. And I don't think that most judges that you would encounter in state trial or courts of specific jurisdiction or things like that, who run for election, actually, happy election day, everybody. Forgot that was today. But that who run for election and things like that, I would say that a lot of them don't have judicial philosophies, that there is a genuine belief that most cases that come before, especially trial cases, there are some really interesting ones, of course, but there's a lot of cases that just do fit very easily into the law. And there isn't a lot of politicization. I do think that this is something that we kind of, I think it's just I kind of, and not to, I don't really want to know if I want to open this can of worms, but I think that the U.S. legal system and our law schools spend way too much time on the federal system and kind of lauding the federal system for various reasons. I think that this is something that we don't talk about enough, and people think that the Supreme Court justices, who are incredibly kind of political for all of the reasons that you said, and we all kind of are aware of, that is a trickle down theory or something that I just don't think holds. Would you agree with that, Orin? Or do you think I'm off base?
I think there are a lot of legal disputes where there's a clearly correct answer, and where judges normally reach those answers, and when they don't, it's that they kind of messed up, not that they were trying to get to some result, just they didn't know enough about or the lawyering was bad, and that's what did that led to that. So I think that's true. I think we also care about the political cases. So if you look at the Supreme Court's docket, we only talk about a quarter of the Supreme Court. It's as if there are 10 cases before the Supreme Court and not 70 or 80. Because if it's not political, who cares? It's those are not the cases that anyone's gonna it's a statutory case involving bankruptcy law.
You don't mean procedural cases are absolutely riveting for the rest of the public?
A lot of people, they just don't care. And so it's a culture wars case. That's what we care about. And those will be the kinds of things that people have strong views of. And those are the kinds of things that people divide on political lines. And so it's a subset of the work that's done. And at least in my area in Fourth Amendment law, what I like about the kind of issues that I spend time on is that they don't divide neatly along ideological lines, because ideological lines are so boring. Wow, there's the left side of the left view and the right view, and the left will take the left view and the right will take the right view, and you count them up, and what is there to say about that? That's not interesting. And then there's a whole cottage industry of law professors that try to come up with interesting things to say about this just ideological divide. And so what I think the fun questions are where there isn't an ideological divide, or where you get kind of left, you'll have a view embraced by a wide range of people, or judges. I mean, what I love about especially the tech law and criminal procedure part of this, judges are what is the right answer? That's hard. And so there's a sense of open-mindedness that you see in some areas that are less common in other areas where the priors are super, super strong.
All right, so let's talk about a divide.
Oh, hold on. I want to just really quickly, we should, but I want to flag that we have to get back to the substantive question that Genevieve raised, which is why no Fourth Amendment cases this term.
That's what I'm doing.
Oh, okay. Sorry.
Ideological divide about the Fourth Amendment that is not left-right in character. Akhil Amar begins his famed Constitution and Criminal Procedure article about the Fourth Amendment, if memory serves, with the line, "The Fourth Amendment is a disgrace." Orin Kerr, Fourth Amendment expert, is the Fourth Amendment a disgrace? Yes or no?
No.
All right. There, we've identified a firm.
What is your beef with Akil Amar, Orin? Jesus.
Why do you hate Akil Amar? Yeah,
why do you hate Akil Amar?
I love Akil Amar. I just think he's wrong on the Fourth Amendment.
I'm joking.
Yeah, no, and this is where, this is where my Burkean instincts point me in different directions than a lot of law professors. A lot of law professors, the whole ideal of an academic view is like a novel theory, a new direction for the law to go in, where everything in the past is bad, and we need to like branch off into this whole new world.
Well, that's what Akil does in that essay.
That is what he does in that essay. That's what a lot of law professors do, and so there's a lot of interest. If you collect them, law professors talking about how terrible the Fourth Amendment is, awful, horrible, disgrace, embarrassment, all this kind of stuff. And I actually think that it actually makes a lot of sense when you put it all together. Now, I'm a Burkean on a lot of issues, so I tend to look for like, okay, what worked in this? What function is this serving? And we can understand it better and see what it's actually serving a lot of important purposes, and it all kind of fits. And so that's my instinct, is to kind of say, actually, there's a reason why things are the way they are, instead of like, let's get rid of it. But I can say that I've written articles that started with the discussion quoting everyone else about how terrible the Fourth Amendment is. And then I said, I disagree, and good. Here's why they're wrong. And the most cited part of that article is that first paragraph where I just summarize how embarrassing everyone else says the Fourth Amendment is, and they just ignore my part.
Okay, so let's use this to pivot back to Genevieve's original question, which is, you have a cool, non hand waving affection for the kind of slow common law development of Fourth Amendment law. The incremental stuff you see where other people see incoherence. You see a complex tapestry of increasing detail and a basically rational way of seeing it, seeing things. And you are relatively complacent, I don't mean that as a criticism, but just as an observation, about the flexibility and durability of this complex sort of Talmudic system for the future. Doesn't that answer Genevieve's question why the Supreme Court can take a few years off if it wants? And like, they had some things to say a few years ago about, location tracking on cars, and now they, want to focus on abortion and Texas's complex, scheme of enforcement, and they want to, do some other stuff, and the Fourth Amendment will be fine for a couple years if they ignore it.
I mean, I want you to answer, Orin, but I'm going to say that this is like, I feel like right now, the way that Ben just described it, it's like that Looney Tunes scene where they they're painting the floor, and all of a sudden they end up in the corner, and they're like, oh crap. And maybe they're just waiting for the paint to dry so they can walk back across the floor and finish the job.
So
is that too harsh about the Fourth Amendment jurisprudence?
So Ben, I think the problem with your view is that it leaves me very little to write about for the next year or two.
You've written a lot.
My interest in getting Fourth Amendment cases on the docket is a purely self-interested.
And for those who don't know, Orin is, I think, the number one most cited law professor by judges in the country, because they all have Fourth Amendment cases.
Wait, it's like more than that. He's just like the number one cited. Anyways, whatever. Like,
assuming arguendo, that
he's written a lot of stuff.
Assuming that's true. No, but for those of us that are all sort of what's the Supreme Court doing and care about changes in the law, you got to get cases on the docket, or else what do we talk about? So that's part of my campaign.
And I do see that as a problem.
This is a public law scholar crisis of legitimacy. And if we don't get cases, we're going to have to talk about lower courts, people. And
Oh
so
my!
let's understand the nature of
Everyone,
this.
let's make some new law because Orin is bored. That sounds like a great
No,
plan.
but to answer your question seriously, I think, I think this is often true. You never know whether the Supreme Court taking a case is going to make the law better or worse.
That's true.
So, I think it's true in a lot of areas of law. If they took a couple of years off, it could be a significant improvement. It all depends on what they end up doing with those cases. Why are they not hearing any Fourth Amendment cases specifically? I think there are two things that are going on. Part of it is probably just luck of the draw in terms of when really juicy issues with a deep circuit split happens to get to the justices on an important question. And then part of it too is that there's, with the technology cases, I suspect they in general want to wait and not try to rush into the tech cases because the tech could change. And so it makes a lot of sense. You kind of wait until the technology stabilizes before you pronounce, here's how the law should apply. So they're doing, I suspect, what the Supreme Court bar would call percolation. That is, sort of letting the lower court sort of struggle with what the rules should be and just waiting for a while until it's much more kind of stable. And then they'll come in and they'll figure out what they want to do.
But with the rapid evolution of technology, is it a realistic thing to think we'll ever get to that point where tech is stable enough that they'll be able to take the time and rule on it? Or would the core principles of the issues being discussed, essentially like a mobile device holding personal information, no matter how much that tech changes, is still the core principle? And is there any like circuit split that you think could be addressed or should be addressed by a higher court?
Yeah, so it kind of depends on the issue. There's some issues I think are surprisingly stable. So, should the Fourth Amendment apply to email? Should it protect the contents of email? Email today is basically the same as email when it was invented, 50 years ago. And so there's not a lot of change in it and the basic idea. And so that's something where, it's basically just content messaging, and that's, I think, fairly stable. Where you run into issues of technology changing rapidly, I think Carpenter, the Supreme Court's case from 2018 on cell site location information, is an interesting example of this. The record of the technology they had was that the cell site records were only within, I think, around a mile of precision. And then there was all this speculation about someone wrote a brief, that's going to change. It's going to become really precise. And then the justices get their case and they're trying to come up with a rule for cell site location information. And the government says, well, this is really imprecise. You only find out within a mile of where someone is. You can't really track them. And the justices are like, we're going to assume this is really imprecise because we think that's where this is going. Well, if they're wrong, their rule kind of looks silly down the road. If they're right, their rule looks prophetic. But there's something to be said for waiting until you kind of know what the facts are going to be in 5 years or 10 years, so you don't have to revisit it.
So,
haven't.
Yeah, I mean, I teach a number of your essays when I teach information privacy. Obviously, I spent a lot of time on the Fourth Amendment and kind of ideas of privacy out of the Fourth Amendment. But one of the things is sorry, and it has been a year since I've taught it, so I'm trying to remember the case, but it's the container case. It's the liking is it
the cigarette?
Yeah, it's basically liking a cell phone to a container that is similar to an empty cigarette pack holding heroin capsules. And so that in a search incident to lawful arrest, which of course is exempt from a warrant requirement, that the idea is that if you have the right to search a perp's pockets and they find some type of container that then has illegal drugs and contraband in it, if that is okay within the search for incident to lawful arrest, then you can search a container like a cell phone. That was right? I forget which case this was.
That was the early
Robinson
cases like this.
I can't remember.
U.S. versus Robinson was the cigarette.
Was the actual cigarette case, right? Yeah. And there were some early cases. So when I was in law school, that was where the law was likening cell phones to those. And the conversation was quickly turning into, well, you should be able to do it incident to a lawful arrest because they can brick a phone or erase it remotely. That was like nascent technology, but that was clearly where it was going, right? And then the other thing was that it was like clearly like this GPS thing in your pocket, and that it was like it was just like the technology had just jumped from like overnight from flip phones to everyone had smartphones. It was like in 2 to 3 years.
Yeah,
And so like yeah. And so I do feel like the court got better, but like I don't know, like how do you possibly have a window on that of like where if you're thinking about the evolution of tech in terms of like some type of periodic evolution, like where do you pick your period that you're going to like start to set down tracks, right? Like I just don't really quite know.
The Jurassic period.
That's where it is right now.
I think as long as you're attuned to the problem, then that's really the answer, is like you just need to focus on it and be aware that there's this question of timing. But I think that slows down the justices from trying to grapple with issues that they might otherwise be interested in if the technology were stable. And I think a great example of this is the Justice Department filed a cert petition last year in a case called United States versus Kano on searching cell phones at the border.
Yes.
And there's a lot of lower court disagreement on, there's like a 5-way circuit split now.
It's also a really, border searches for people that don't know are very compelling for national security. And like, first of all, they're compelling just doctrinally. There has been great latitude given 100 miles, like from every border to Border Patrol, like have like this ability. And full computer searches have always been, I mean, I seem to remember like there's that case in Vermont. Sorry, I can't believe I can't remember case names. I've never been good at this. I'm the worst law professor ever. Like, I would go in to talk to my judge having just read a case and been like, like, and give the entire fact set and not be able to give them the name of the case. But anyway, I do think that like this is just so. Anyways, there's a total exception made for border, like not an exception, just a much lower standard for needing a warrant. Right? Yeah.
Well, so originally, yeah, the traditional rule is when property crosses the border, it has no protection whatsoever, and so government started searching cell phones and laptops crossing the border, and then the Ninth Circuit started saying, this was in 2014 in a case called Cotterman. Well, reasonable suspicion should be required to search a phone rather than no suspicion, because there's so much stuff on the phone. And then, other lower courts started saying, yeah, well, some agreed, some disagreed. And you can see the direction of the law is towards greater protection. And if we wait another 2 or 3 years, I'm guessing there's going to be a circuit that says the border search exception should not apply at all to searches of digital devices over the border, which I suspect is probably the right answer, sort of taking a big picture look at the border search exception. And
it's a huge loophole.
The technology
100 miles is huge.
There's some of that is like an extended border search rule, which some circuits have, which is sort of its own technically. We're not going to get too technical on that, but there's the technology is changing. What people bring across the border is changing. Technological alternatives to border searches are changing. So, if you can just encrypt your files and bring it across the border or pop it up into a server somewhere and then get it from where you are, then it may not matter what the border search exception is. And so,
and similarly, right, if you pack cocaine or fentanyl into your cell phone and they search that without a warrant, I don't think the Ninth Circuit is going to say, the border search exception is about like what you physically packed into your phone rather than that what is right. It's like, it's not the physical object of the phone. It's the data stored on the phone.
That's right. Yeah, there actually have been some cases of cell phone search in the sense of like taking apart the cover and finding something underneath the cover. And then courts have said, that's not what we mean by a cell phone search. That's just a physical object.
Yeah, I do. I actually do remember. Yes. Okay. Also, like,
hide your contraband in cell phones and laptops, people. That's the key advice coming out of here. You at least have an argument that you don't have if it's just in the bag.
Just like an entire computer built out of cocaine.
Yeah.
Like that's
Quite a brick.
great. Yeah. Sorry, we're
Ouch.
full of good ideas here. Yeah. Oh wow. Thanks. Good one, Genevieve. So sorry, Orin, continue with what you were saying. I think that we kind of like interrupted you.
No, but it's all a good reason why the Supreme Court is better off taking its time. Wait for another case. This issue isn't going away. And that the quality of a decision you might get if the Supreme Court takes this issue in 2025 is probably higher than the quality of the decision you would have gotten in 2021 if they'd taken this case. And so this is all a good reason to wait a little bit, as frustrating as it is for public law scholars who want cases to write about. So these are all good reasons why just everything's taking time. But it is kind of amazing how much time it's taking in some ways, because like the Supreme Court first started talking about new rules for digital Fourth Amendment stuff like 10 years ago, maybe, depends on which case you consider, Jones,
Yes.
maybe in 2012.
Jones, I would say, yeah.
And then
Oh my
Riley
God,
in 2014 and
Jones
Carpenter in
2012
2018. Yeah, these are like, time is moving. And so this is coming really slowly over time.
Deliberations in law school. Holy cow, I'm really old.
Yeah.
That's terrible. Oh man.
Yeah, so time is the cases are evolving slowly. There's a ton going on in the lower courts, but at the Supreme Court, not much is happening right now.
All right, before we go to audience questions, I just have one more small question. If you could have a law enforcement agency in front of you and a criminal in front of you, and you could design the perfect fact pattern, tell both sides what to do, maybe there's a tech company there too, you instruct them, they will follow your instructions to tee up the perfect Orin Kerr wants to write a law review article, and the Supreme Court needs to consider this issue to really make it timely. What would you tell the criminal to do? What would you tell the platform to do? What would you tell the law enforcement to do? The only consideration is, because that's what we're talking about here, is your academic gratification.
This is a good question.
It's just a quick question before we go to audience.
Yeah, so I would actually say, I have an article forthcoming on internet preservation when the government sends a request to preserve an email account, and whether that's a Fourth Amendment seizure, and if so, what needs to justify it. So I would actually say this is super easy to do because this happens like 100,000 times a year. Just have a defense lawyer challenge the preservation, because that's a problem where the fact pattern happens. I mean, I'm most interested in things that are happening anyway. What I'm concerned about is there litigation on it? So I would basically tell defense lawyers, please file these challenges rather than just plead guilty.
So what's a preservation order for those who don't know?
So there's a statutory authority. It's actually just a request.
Yeah.
If you're an FBI agent or any government, any state or federal law enforcement agent,
you don't even have to be a government
you
agent
have to
to
be an
file
agent.
you can just be. It can be done in private actions.
Well, it's not legally binding though in private action.
Yes,
so
no, it's
it
not,
has to be.
but-
It has to be a state or federal government employee. Can say like, Witness might be involved in crime. I want you to copy all of Witness's email accounts and hold them for 180 days. And the provider will say, okay, that's cool. Some police officer or some agent said to do it. So they will actually run off a copy of all of your emails, your entire account, and just hold it. And you could decide to delete your account or delete your emails or whatever, but they will still have a copy of it. And if later on the government has probable cause to get the contents from the provider, they will then turn over the copy that they had stored, 180 days before. And so this raises super interesting Fourth Amendment issues of, is it a seizure? Is it a government seizure? When is it a reasonable government seizure? Because right now the government does this without any cause at all. And they do this like incredibly frequently. Especially with Facebook, because everybody's got Facebook, or so many people have Facebook accounts, and they have them in their own names. So if the government has a suspect, they'll just be like, preserve Orin Kerr's Facebook account, and the Facebook will do it without asking any questions at all. No court order, no nothing.
Does it matter if the user is an American?
No.
Okay.
No. I mean, that might determine whether they have Fourth Amendment rights. But the authority is just for any account. And so that's one that I think that's going to be a super interesting issue once the courts start considering it. And the only reason the courts aren't considering it is defense lawyers aren't making this argument. And so I want to push them to do it.
I think that's fascinating. I really like that. That sounds great. I cannot wait to read that article. That sounds like really, really good. Separately, can I get the court to preserve my email exactly as it is at inbox 0, and then I don't have to answer people anymore, Orin?
Absolutely.
Okay,
file,
great.
file an inbox 0 request.
Is this legal advice?
In any court, and they will be. No.
You know Jonathan Rauch's no mail service. It's going to be made up to look exactly like Gmail, yeah. But whenever somebody sends you an email, it sends it directly to the trash and sends them a notification that that their mail has been disappeared and you will never respond to it. And
I love that.
It always says to you, "Congratulations, you have no new emails."
That's amazing. It's
nice.
Yeah, I would love that. Dr. Doom, you're lurking in a voice-only presence. Go ahead with your question.
Hi. I guess I was voted up here. Wow.
Yes, you were.
You're very popular.
Professor Hatch, I've got to say that the degree of self-delusion required for the justices to deem themselves apolitical is just wholly not believable. What real evidence on the things that they care about is there for that, in which they have a conflict? And Amy Coney Barrett, for instance, is risking her eternal life if she votes for Roe v. Wade. If she owned Apple stock, she wouldn't be able to judge a case involving Apple. Why shouldn't she be recused from a case like this?
But why should she be any more recused than somebody who believes with all her passion that somebody should have the right to make an abortion decision herself? Why is belief on one side more controlling than
because she risks
on the other side?
She risks something of infinite value to her. Just as somebody
you're applying now a standard that's radically would radically affect religious people more than irreligious
yes
people.
It would, wouldn't it?
Interesting. Orin?
I mean, I guess if we lived in a world where that was the recusal world, there would just be someone who with identical views to Justice Barrett who had them on purely secular grounds who would be nominated, and we'd be in the same situation.
Yeah, I think that's right. There's always the idea that I do see Dr. Doom's point, though. I kind of want to make a case for this, which is I don't actually think I'm always kind of err on the side of I think people misunderstand recusal and how justices can be impartial. But I do think it is a little strange that we assume so much that financial factors are so dispositive in recusal decisions and such a bright line. And I think that his point that if wouldn't you rather have 100,000? Wouldn't you rather have which would be worse, losing $100,000 or eternal damnation? If that's what you truly believe, or that would be the outcome of a given decision that you have,
I'm sorry, but we don't demand recusals based on people's beliefs.
No, I know, Ben. We're arguing about the fact he's bringing up the fact that if we think that people can't set aside their beliefs or their interests when it comes to money, why do we think that that an eternal decision would basically be something they can't set aside?
I totally understand.
Okay.
But let's leave the eternity out of it and just say strongly held. But every judge has prior articulated strong beliefs because of cases that they've ruled on. And you can't say, well, Justice so-and-so dissented in this case and took the following position. he clearly believes it, so he should recuse from this case. And I don't really see how strongly held views, religious or not, as articulated in opinions, are different from strongly held views articulated in law review articles or under oath Senate testimony.
Isn't there also an argument to be made that if her jurisprudential choices, or any person's jurisprudential choices, came too strongly to reflect their own religious views, that you could argue that they were and it was very overt, that they would be then mixing church and state, and therefore you'd have something where you could say it's not good behavior? I mean, that would be something that you could raise theoretically as a challenge. I mean, maybe, who knows? Questioning how religious a person is, and it implies that they're incapable of separating their civic decisions and their jurisprudential knowledge from their religious beliefs, and that's a little scary.
Yeah, and similarly, somebody who's not religious, would we assume that they can't decide a case involving religion because they don't have a personal experience with? I mean, I think they're all judges. They're all going to have strong views on some issues, not so strong views on other issues. Let me go back though to the big question of sort of whether the justices are always acting politically. I think the one test for whether a judge is acting politically is whether, when they look at their rulings, do they think, God, half of these are stupid. Half of these are so dumb. I can't believe the Constitution protects that. That's ridiculous. But the other half, they still seem to be good. And we don't have many judges who have that view of their rulings where they agree with half of them and disagree with half of them from a policy standpoint. And I think the fact that we have so often agreement between what judges would like to see in the world and their views of the law is a sign that they're being influenced by those factors. But it's fairly rare to find those people who are not being influenced by those factors. So one I posted this on Twitter recently. It's always bad way to start a conversation. But if you think the other side is acting politically in the Supreme Court, do you think your side is acting politically in the Supreme Court? And this is what struck me as kind of real interesting thing. Those guys, they're political. And I think they're wrong 100% of the time. I'm always on the other side of them. They're political. I'm not political. It's like, well, wait a minute. If you're always on the other side, aren't you being equally political? And, some people on Twitter are like, oh, okay, well, maybe. And then other folks are like, no, I'm rule of law. They are political. And I just think there's a natural correlation between those views, and it'd be better if there weren't. I'd rather live in a world where there isn't. But realistically there is, and that's the system we have.
I completely agree with that. There's no way that the liberal justices aren't. I mean, we call them the liberal justices. There's a voting block and they're all the same. I mean, it's absolutely correct. And just because I agree with them doesn't, yes, I completely agree with that. It's a very political type of position. That doesn't mean that people also, as Ben has stated, cannot change their beliefs, both on cases that have come before them and on any facts that are before them, or kind of or anything else. I still think that this is my point about recusal and money, though, is a good one. Why the hell do we care so much about that? I don't give a shit about money. So why I shouldn't have to if I'm ever a judge, I should never have to recuse myself. I don't know. That's just kind of,
we care about it because it's objective.
It's objective.
Yes, I know.
It
just seems measurable. It's just
right.
Yeah, exactly.
Well, also because the sense of interests, as in conflicts of interest, actually refers to money.
Yeah.
And it's ruling. It's ruling on a matter in which you have an interest, meaning a stake financially in the outcome, is literally the meaning of conflicts of interest within it in this sense.
Yeah. Richard, please ask your question. Nice to see you, sir.
Nice to see you. Nice to see all of you. Even Elizabeth Holmes. Never mind. Okay.
I see what you did there.
Yeah.
Bruckner, man.
There are worse things to be.
Maybe we should ask Orin Kerr to resolve our dispute about Bruckner.
Does this mean that I'll never have to hear about it again?
Orin Kerr, Richard and I have a long-standing dispute about Anton Bruckner. Without telling you who's on what side, Anton Bruckner, thumbs up or thumbs down?
Oh, no, I've actually never listened to any Bruckner. I'm totally making this up. I have no views.
No, don't do that. We almost were done with this.
You will never.
Something good.
At your funeral, Kate, we will be arguing about Bruckner.
Is there a piece that I should start with? It's like representative?
None. No, there is not.
Anyway. Hi, Richard. Thanks
Hello.
for coming on.
Thank you. Well, nice to see all of you. I'm just curious, Orin, about your thoughts about the competence of judges in the federal system, including Supreme Court, to deal with the technology that's behind a lot of the cases. And I realize it's a wide spectrum. There's some that will actually get in and even learn to code and things like that, and that strikes me as sort of the exception rather than the rule. So I'm wondering what you think about it, and does it matter?
When they learn to code, little known secret of the Supreme Court, actually the only program they learn is in BASIC, and it is 10, print high, 20, go to 10. No. For those of you that learned BASIC in the 80s, that was like the first program they had used.
Joke, Orin.
Thank you. Yes, a little better than Bruckner. I mean, I know nothing about it.
I know, right? Because some of us have standards.
So yeah, this is a constant problem for them, and I think there are a couple solutions. One is that amicus briefs that explain the technology can go a long way towards giving them some idea as to what's going on. And I think clerks probably can play an important role in explaining the technology to their justices. And just awareness that this is a problem is something that helps. There were early cases. There was an oral argument back in 2008 or something like that involving pagers, and the justices made all sorts of silly comments during oral argument that made obvious they had no idea how the technology worked. And they looked there were like New York Times articles about how silly their comments were. I think after that, they got a lot better and were much more careful. And in cases like Riley, less so Carpenter, but Riley is maybe the best example in 2014, very self-consciously focused on accurately describing the technology, like pages of sort of like, we are going to engage with this carefully. So I think it's always a dynamic, but one that they can solve by just being really careful.
Okay. Let's see. Christopher. Go for it.
Good evening. Hi, Orin.
Hi.
Professor Kerr. So for I don't want to call it us amateur court watchers, but for those who may only tune into like one or two oral arguments a year and aren't intimately familiar with like the nuances of a case or know every single ruling that a justice has gone through, how do you rate those who say things like, oh, well, this justice seemed very skeptical of the arguments, like based on their questions or comments during oral arguments? How much can we read into or not read into, and can we dispense with the idea that you can predict
based on oral arguments,
like the swing justices at least, and for every like comment from Clarence Thomas that makes it sort of seem like he's going beyond his like obvious position or presumed position. I mean, do we just sort of say, let's see how they rule and not figure it out from the question?
Yeah, so some justices will have a track record on that issue that gives you a pretty good idea of where they're going. And some justices are asking, there's a wide range of questioning styles which give you some idea. And some justices make really clear, like, they'll be like, "So, counsel, please, surely you are not arguing the following position." Like that's really clear where they're coming from. And other times there's just sort of like more like good faith, like I'm struggling with this question, I'm not sure of what to do, and what do I do with this? What do I do with that? And so they each have kind of their style, and when you're familiar with each of their styles, you can kind of get a feel for where the different ones are coming out. But a lot of oral argument is also about persuasion, justice to justice, and so
Yes.
this was especially true when you had like Justice Kennedy in the center, or Justice O'Connor in the center, where there was a lot of questioning, which was like, counsel, isn't it true that? And they'd kind of be like looking at that swing vote, like here's something to think about. And it was basically making arguments through questions, and the counsel sort of was almost irrelevant to that role. And so you can't really, you can get senses of what that justice was trying to do from the question, which gives you some feel for which side they're on. And so you can get a feel for kind of where things are going from that. But it's like knowing, it's like listening to a conversation of people right, or friends of yours, your neighbors. I gotta feel that my neighbors were trying to do this, or I gotta feel that this is where the views were. And it's not an exact science, and sometimes you just have no idea how it's going to come out, and sometimes they don't know where it's going to come out. So you kind of have to wait and see.
But there was I believe she was a Georgetown law student. I'm not sure, but it's I forget her name. She did a study of could you predict justices' rulings by oral argument, because everybody says you can't predict what a justice is going to do based on oral. And her conclusion was what she did. She listened to,
she coded it session. Up. I remember
she
that.
Coded it up.
Yeah.
How often
and found that you could actually totally predict what justices were going to do based on oral argument.
Yeah, I think that the tell that some have focused on is just justices ask questions to the side they disagree with. I think that was the, like basically when someone gets up there and they start saying all these things that you think are totally right, you're just basically sitting there going like, yeah, that's totally right. And you don't need to say anything. But when you're like, that's completely wrong, that's when the justices will tend to talk. So I think it was like the amount of time they spent speaking was a signal of which side they were on, which I think is right. Apparently, that makes sense.
Yeah. I have a really important final question for you that comes from Matteo, who we couldn't get to come on. But Matteo asks, if a surgeon were reasonably suspected of hiding a murder weapon within the body of one of her patients, would the Fourth Amendment prohibit investigators from cutting the patient open to retrieve it? What does this turn on? I think that, yes. I'm really sad that we didn't get to ask this in like Halloween or something. It feels very ghoulish.
So this does come up in cases, and the Supreme Court said in a case called Winston versus Lee that it's a reasonableness balancing test as to whether a warrant can be obtained. So a warrant is needed to retrieve something from a body, but there are some cases where a warrant can't be obtained. Yeah, if you've got it, good, that's perfect.
You gotta have a warrant to do that.
So in Winston versus Lee, it was a guy who had a bullet in him, and they wanted to pull out the bullet to see if it matched the suspected
because it was like a bank heist or something. I feel like he'd taken one in like collateral.
And basically it was like the claim was, if you withdraw this bullet, it could kill the person because of where the bullet happened to be lodged, and so don't withdraw the bullet. And the court said basically, if it's going to cause dangers to the life of the person who has the evidence in them, no warrant can be obtained. Otherwise, a warrant can be obtained. So it's a warrant rule, but sometimes it's actually the one area of Fourth Amendment law where the Supreme Court has said it's so sensitive or so private that even a warrant can't be obtained based on probable cause.
I just remember so deeply in my Fourth Amendment class when we were learning plain view doctrine, and the entire class just quizzing our crim pro professor and asking her all these questions, and it finally ended up with, what if it's a midget policeman and they're standing on a ladder and they see something at the top of a and it was like this crazy like kind of construction, like, is that like in plain view?
Then Orin would have a law review article to write, and he would be sated by the docket, whereas now he's twitching with irritation and boredom.
Yeah.
Well, I just hope my appearance on this show can help bring attention to the cause of more Fourth Amendment cases being needed on the docket, because it's a public awareness campaign more than anything.
Yeah, no, I think that we hear you, and you're pleased.
Keep Orin Kerr in papers. Yes,
we will all tweet about the problem, and
I thought we all agreed that it was a good thing that they stopped and took these breaks and let the technology like accumulate, percolate. Except for Orin.
I don't think Orin agrees with that. I think Orin is, he's jonesing.
Yeah, it's good for the world. It's not good for the professors.
Oh boy.
We are gonna leave it there. Orin Kerr, you're a great academic. You're a terrible American. Wishing for the premature consideration of issues for your own personal gratification here.
Thank you for coming.
Thanks for coming back. We will be back tomorrow. I will be a little bit more with it, I hope. I have no idea who's going to be on the show tomorrow. I'm not sure any of us do. But listen, all of you, your pleas have been heard about the Tucker Carlson documentary. We are putting together a watch party. Scott Shapiro and I and Mike Pesca. We're going to all watch it at the same time and record our reactions. So you don't have to. So stay tuned on that. I was going to do that this evening, but I just don't feel up to it. All that will start 22 hours and 59 minutes from now. And until then, Orin Kerr.
I don't think he knows the sign.
And until then, Genevieve.
Oh, we can't have fun.
Yeah, we don't have fun anymore.
We don't have fun anymore. Sorry.
No, you got it.
And we can't even have
fun.
Fourth Amendment cases from the goddamn Supreme Court.
Yeah,
Seriously.
there we go.
Defense attorneys, please.
Come to our aid.